Hi, welcome to this video. I'm talking today about fighting the administrative actions of the Trump and DOGE teams in respect to the reductions in force that are happening right now. This is being shot in February of 2025. So we're very early on in the process, but I think it's important for employees to understand what their rights are. Today, I'm primarily going to be talking about tenured employees and people who would otherwise have tenure, such as veterans preference eligibles. So please understand this is just background information for these reductions in force. If you have specific questions about your situation, you should definitely contact an attorney and do so as soon as possible. I'm going to talk about the deadlines that are coming up. These don't necessarily apply to probationary employees, and that is why you need to have specific advice for your specific situation provided to you. So this is not going to be legal advice. This is just legal information to help you understand the background and the potential challenges that you can make in challenging these reductions in force that are forthcoming. Hopefully not, but they seem to be proceeding apace as of February 2025. Background here, just so you know, all of the claims that non-probationary employees can make concerning the reductions in force will ultimately go through the Merit Systems Protection Board, the MSPB. The deadline for filing a challenge to the RIF process is going to be 30 days after the effective date of the reduction in force. Alternatively, an employee can challenge a reduction in force case based on discrimination. I'll get to the specifics of that later, but that has a 45-day limitation. Just so you know, if you wait beyond those deadlines, you're most likely going to lose your right to appeal the case. Depends on your particular circumstances. There are a few exceptions to this, but the vast majority of people need to be on top of this. So as soon as they receive their reduction in force notice or their reduction in force is affected, that appeal needs to be essentially in process at that point and meet these deadlines. So there are technical errors with reductions in force that you can challenge. And one of the main ones is going to be the register. It's called the retention register. This is where all of the employees are grouped into specific groupings, and then they will be terminated in reverse order. So the person with the lowest level on the retention register for each of these groups is going to then be either terminated or given bump or retreat rights, which means that they can go down a few levels to take over somebody else's job. So one thing that can also be contested here is once that retention register has been executed on and the person is receiving bump or retreat rights or not, that person can then challenge whether those bump and retreat rights were implemented properly. Is there somebody who is on one of these retention registers who has their information incorrect in the register such that the employee would be able to either bump or retreat to that person's position? These could be errors just in calculations coming from HR. HR is not perfect. I'm sure they are using some kind of automated process on this, but that doesn't mean that the information that's going into that automated process was initially correct. There's also issues with veterans because veterans have special preferences, particularly USERA rights and things like that may lead to a challenge and may lead to a decision on a different basis. So if somebody has veterans preference rights, that's a good reason to reach out to an attorney at this point to figure out what are those rights and how can you use those rights to challenge a reduction in force. So there are also discrimination and retaliation claims. These are filed with your EEO office. The major concern here is that a reduction in force can actually mask discrimination or retaliation. And there's a number of ways that this can happen. These have appeared in cases before, and they can be particularly difficult to find the evidence to prove. But if this reduction in force is coming for you as an individual, it really speaks to the fact that this isn't a reduction in force. This is just a termination. And if it's just a termination, then they have to follow Chapter 75 procedures, and they have to show that this is for the efficiency of the service, or follow Chapter 43, which they're not going to have done. I'll cover that in a moment. Prior discriminatory acts can affect a reduction in force. For example, the agency may be using a discriminatory performance evaluation incorporated into the overall reduction in force decision. If that's discriminatory and that leads to somebody not being retained or being forced to bump down, then that's an act of discrimination. And that can be challenged through the EEO process. It could also be challenged through the MSPB process. The specifics of what you need to be able to show discrimination, that's going to require a substantial amount of evidence, and that's going to need to be collected. you should definitely speak to an attorney if you think that what's going on with the reduction in force or how you have been reduced in force or where you've ended up on the retention register has been influenced by discrimination or retaliation. There's also an overall regulatory challenge that can be brought to specific reductions in force. This is a bit harder. This is a bit more complicated. And this has less to do with you as an individual and more to do with the reorganization, how it's being performed. What we know right now, and we're guessing about as to the future, is that entire agencies are going to be eliminated. In fact, USAID seems to have been eliminated at this point. The government or the administration is looking to the Department of Education. Likely there will be more cuts coming to specific departments where entire departments will be eliminated within an agency. It's not clear yet what that's going to be, but one way of challenging this is to look at whether this is in fact a real reorganization. Under the regulatory requirements for using a reduction in force, the agency has to prove that this is a reorganization or that there's a lack of funding. There are 4 or 5 different categories here that the agency can prove to be able to show that it is entitled to use the reduction in force regulations that are out there. The MSPB will take a look at this and ask the question, is this a bona fide reorganization? I think there's a question about whether this is a bona fide reorganization if the positions are still going to exist and they're planning on refilling those positions in the future with individuals who have fewer protections, such as what used to be called Schedule F. These reorganizations, though, are subject to not a lot of scrutiny from the MSPB. The MSPB gives the agencies a lot of leeway in determining what constitutes a reorganization for their purposes. And it is a potential area for challenge. I think it's going to be something that is very difficult to prove. And the MSPB is largely going to throw its hands up and say, hey, the agency gets to decide ultimately what a reorganization is. If they want to reorganize themselves out of a number of employees, that certainly is not for us to challenge. I think these questions have not been answered yet in terms of whether the MSPB is going to accept what the administration is claiming is a reorganization as a reorganization, but that's just one thing to know going forward. There's also a question about compliance with procedural requirements. Have they done all of the things that are required under the regulations for this? And I've talked about where those regulations are in a past video. I'll link it in the description below. One thing here to understand is that if the regulations for reductions in force don't apply, if we can set those regulations aside, then what we're doing is challenging the reduction in force based on Chapter 75 or Chapter 43 principles. These are the 2 chapters in the regulations that allow agencies to separate employees essentially for cause. So Chapter 75 is for the efficiency of the service. Generally, it's known to be about misconduct, but it can be about performance as well. And then there's Chapter 43. Chapter 43 provides a lengthy performance improvement process, but at the end of that, if management still feels that the individual is not performing up to standard, then they can terminate that employee. For reasons that probably are pretty obvious, Chapter 43 is not the way that the agency is likely to go in any of these cases because they would need to go through this performance improvement process, and they don't seem to have any interest in doing that. I've not heard of any plans to subject any employees to a performance improvement process, even though allegedly performance is the issue. Chapter 75 procedures are then going to be the fallback, most likely, from these regulations. So if the agency employs the reduction in force regulations, most likely the fallback from that will be Chapter 75 for the efficiency of the service. That requires charges, much more than would most likely be acceptable under a RIF notice. So just to understand that is where this goes. So if the RIF regulations don't apply, then it becomes a Chapter 75 case. In a Chapter 75 case, they've got to meet all sorts of procedural requirements that they may not have to for a reduction in force, including an opportunity to respond and things like that, due process rights that are going to apply. So challenging the regulatory scheme that this is being brought under may be extremely helpful for employees, particularly if there's no other basis in the reduction in force to challenge it. There is also a general administrative law argument that is coming out, and it's being used by a lot of the unions right now, but is likely to come up in the future. And it's complicated, as you might expect. What the challenge is based on is what's called the Impoundment Control Act. Little history lesson. Prior to the 1970s, Congress would obligate money, meaning it would appropriate money. Once it appropriated that money, the president was supposed to spend it. There were certainly instances where the president didn't spend that money, going back to really the beginning of the Republic. But in the 19th Congress passed what's called the Impoundment Control Act. And what that act says is, if we appropriate money, you have to spend it, right? That's the only real power that Congress has at the end of the day. It's one of the principal levers of power that Congress has, is to be able to appropriate money for programs and to basically instruct the president to go ahead and fund these programs. You do it however you want, but make these programs happen with the funding we are providing. The ICA, the Impoundment Control Act, says you can't just say no once we appropriate that money. You have to use it. And so an impoundment is where the president says, I'm not going to spend that money and I'm going to withhold and retain that money. The other side of this is that Congress appropriates a specific amount and the president can't ask for more money than that for a specific program or outside of what Congress has appropriated for. We heard a bit about this with the fork in the road emails that DOGE was promising to get money to people when it couldn't obligate Congress to. Here, the core is that agencies must spend the authorized funding, meaning that if it's authorized, if it's appropriated, the agencies must spend it. How does that conflict with the reductions in force? If there's a reduction in force, how is that money being spent? Is that not an unlawful impoundment? It'd be one thing if Congress stepped forward and said, we will give you this money, but if you do a huge reduction in force, you don't have to spend this amount of money. You have to spend this lower amount of money or something of that nature. So we're dealing with right now, and will be coming up a lot, is what obligation do agencies have to spend the money, including on federal employees. There are some better arguments and there are some worse arguments on this. A lot of these cases come down to whether there is an ability to challenge this under the Administrative Procedures Act. So the Administrative Procedures Act says if the agency has an area that is delegated to it, that the courts are supposed to give deference to the agencies in their determinations, then the courts say we can't do anything about that. That's going to be a lot of the programs. A lot of the programs that the United States agencies have are just funded in non-specific ways, at least as to federal employees. There are others where that's not the case. So there are, for example, instances where Congress has said you need to hire so and so many people in this area, or so and so many agents, or so and so many officers. Now, if the administration goes below that number, there's a very good argument there that the Impoundment Control Act would say, no, you have to spend an amount of money that we have appropriated to you to at least reach that threshold number of officers, agents, or whatever number of employees. That's probably not the vast majority of employees. And so what we're looking at here is probably a lot of litigation about what scope these federal agencies have to be able to avoid spending and to withhold spending on things like federal employees if it's not going to meet that target, given that there is the Impoundment Control Act. Last thing about the Impoundment Control Act is, it hasn't been challenged on a constitutional basis. And previously the Supreme Court, not reviewing specifically constitutionality of such requirements, but has approved cases where essentially saying this is constitutional. The administration right now claims that it's not constitutional, that the Article 2 powers, Article 2 is the executive, Article 1 is Congress, Article 3 are the courts. So Article 2 powers are in essence absolute as to this, and the executive doesn't have to do what Congress says in its appropriations. That's highly questionable. That's an area of law where nobody has even bothered to ask that question before. And when it's come up before, that question has not seemingly bothered the courts. So it's unclear whether that ultimately is going to be proved by the courts as a viable theory here. It's really up in the air. This is one of the administrative law challenges that is out there that litigants are taking up. This isn't necessarily something that every litigant is going to be able to utilize, but it's important to know that it's out there. If this is something that can be pursued, should be pursued by anybody who's subjected to a reduction in force, where the Impoundment Control Act would otherwise give them a forceful argument saying, no, you have to actually employ me and my coworkers here because we are doing the agency's work that is required by Congress. So thank you for listening today. I know that this is a time when a lot of individuals working for the federal government are incredibly concerned about their rights. This is really a very good time to speak with an attorney and to get that process started so that if you do receive a reduction in force notice, that you start gathering the evidence that is going to help you prove one of these challenges or one of the other challenges. These are certainly not the only challenges out there, but one of the challenges to the reduction in force that is seemingly forthcoming. If worse comes to worse, please reach out to an attorney to get some advice on how you can challenge these reductions in force and save potentially your federal employment. Before you go, if you're watching this video, it's early 2025, and you have questions about your reduction in force, check the information in the description below. I'm going to leave a link to where you can sign up for a time to speak with me for 15 minutes about your reduction in force issue. And if there's more that we need to take a look into, then I can schedule you for that. Please take a look at the description below, figure out if this is the right thing for you.